Presumption. Happy New Year. We hope that all of you have a great holiday with your families and friends. And we're excited to be back. We may go through some slight programming changes, but we are back in full force. And I'm here with my esteemed colleague and partner in crime, Jim Griffin.
Hey, Sarah.
And Matt Fondelier, our producer extraordinaire. And
Happy New Year, everyone.
And the wonderful man that you see on the screen joining us, who I had the honor of recently meeting, but I've known for years, is Lanny Davis. Lanny, welcome to the show.
Thanks for inviting me, Sarah.
All right. Lanny Davis is the co-founder and partner of the law firm Davis, Goldberg, and Galper, and co-founder and partner of the public relations firm Trident DMG. He's a lawyer, crisis manager, consultant, author, and television commentator, providing strategic counsel to clients under scrutiny on crisis management and legal issues by combining legal, media, and political strategies. Lanny develops and manages communications programs around litigation and crises to protect brand reputations. Lanny represents individuals, companies, and countries in high-stakes global crises, litigation, government investigations, and crisis management. He has conceived, created, and led media strategies for clients that have included CEOs, sports celebrities, political leaders, world leaders, and both U.S. and international companies. He's handled the cases of public figures from Martha Stewart to Dan Snyder, companies from Whole Foods to Starbucks, and political figures from President Bill Clinton to Representative Charlie Rangel. Most importantly, Lanny is the antithesis of today's divided America. Though a Democrat, he has friends on both sides of the aisle. During the Clinton administration, Lanny served as special counsel to President Bill Clinton and was a spokesperson for the president and the White House on matters concerning campaign finance investigations and other legal issues. In 2005, President George W. Bush appointed Lanny to serve on the 5-member Privacy and Civil Liberties Oversight Board created by Congress as part of the 2005 Intelligence Reform Act. Lanny went to college with one president and law school with the other president. So good friends and good places. Beginning in 2018, Lanny has been counsel to Michael Cohen, personal attorney to Donald J. Trump within the Trump Organization. Michael Cohen will be a key star witness in the criminal trial of Trump scheduled for March 2024. This is the trial that the New York AG's office is bringing. Lanny has authored 6 books with a 7th coming soon to all bookshelves near you. So I'm going to, turn it over to Jim. We are the Presumption podcast. We do believe that everyone deserves a fair trial. And that goes for both the cancel culture and, of course, due process in court. So I'm turning it over to Jim to talk to you a little bit more about something recently you did.
Yeah. Hey, Lanny, and it's an honor to speak with you. Welcome to the show. It truly is an honor. I've followed your career for many, many, many years, and
thank you.
And you're a consummate attorney, no question about that.
Thank you so much.
So we just passed the anniversary of January the 6th, and you and Sarah recently did a mock trial where you were actually the prosecutor for against Donald Trump, and Sarah defended Donald Trump in election fraud claims. And I think Matt's got a clip that he's going to play for us of that right quick, and then we're going to follow up with some questions.
Lanny, what do you make of the First Amendment argument?
Well, it's a bit shocking.
I know you're a very big defender of the First Amendment. So
I am.
I'm curious to see how you feel about this.
I'm a civil libertarian defender quite strongly. But you can't use the First Amendment to protect shouting fire in a movie theater because that causes harm if there's no fire. You certainly can't use the First Amendment if somebody knows that they're lying to undermine our Constitution, our democracy, on the counting of people's votes honestly. And 61 judges all said, show me the evidence. And some of his lawyers in the courtroom said no evidence. And I challenge my distinguished colleague as I challenge respectfully Mr. Trump. Not one single fact has been introduced by Mr. Trump or his lawyers showing enough voter fraud to change the election. That's why his own attorney general said no. His own White House counsel said no. 61 judges said no. And by the way, the last judge in Pennsylvania did find some voter fraud, but not enough to change the election. So it's 61 out of 61. So I challenge Mr. Trump, my distinguished colleague, Tell me one lawyer that cited facts to show enough fraud to change the election. The answer is, to date, silence. The answer is because there are none.
Sarah, you go ahead, Sarah. I was going to prompt a question, but I think you want to go for it, so go for it.
Yeah, well, his advisors, many of whom were lawyers and constitutional lawyers, did share in the same beliefs, and there's ample evidence of that. But let me say this to Mr. Davis. Where there is smoke, there is fire. So you're talking about yelling fire in a movie theater. Where there is smoke, there is fire. President Trump smelled and saw smoke and saw flashing lights and genuinely believed there was a fire. He called on the fire department to investigate. They came and they too saw the smoke, smelled the smoke, and saw the lights and agreed, there must be a fire. We need to investigate. An investigation is at least warranted. So yelling fire on January 6th and in the weeks leading up to that time was really based on a genuine belief that there was, in fact, a fire. That fire being election irregularities that had to be investigated. And because that speech pertains to a matter of politics, it's not a crime. It's at the core of our democracy and our elections. It is speech protected by the First Amendment. I mean, what else can I say?
Wow. She's good. Now you know what I was saying about being up against Sarah.
Yeah. So, Lanny, before we came on the air, you did give a great compliment to Sarah that she kicked ass during the defense of Trump. And so
very kind.
I doubt that. But following up on what, you said as the, prosecutor here, Lanny, I mean, has there ever been a politician that didn't look the camera and look American people in the eye and lie to them? I mean, so Donald Trump's out there, misstating what happened in the election. And I do think that the, January 6th riot, he engaged in reckless conduct. But, I mean, did he incite a riot to the level of that would go beyond the presumption of innocence and the proof beyond a reasonable doubt? I mean, what do you think?
Well, of course, I think he did knowingly and willfully lie. It wasn't a belief. It was a lie. He knew he was lying when he lied, and that's going to be up to the prosecution to prove beyond a reasonable doubt. Proving mental state of mind, Sarah very effectively has pointed out, is a great difficulty for the prosecution, and we'll have to overcome that in order to convict Mr. Trump. I would respectfully disagree, and I think probably Sarah will agree with me in the disagreement, that where there's smoke, when it comes to due process of law, there is not fire. That's the problem with what we're going to be discussing today, involving specific instances where instead of a presumption of innocence, there was a presumption of guilt using smoke, innuendo. That's the nature of the disease of today's media culture and most Americans who think the word indictment is the functional equivalent of guilt, when an indictment is nothing. It's not evidence, can't be introduced as evidence. It's one-sided presentation by prosecutors to a grand jury who votes based upon a one-sided argument. So I would say that the presumption of innocence is a great title for this podcast. I'm really honored to be on and to admit that, especially having gone through this with Sarah, this is not an easy case for the prosecution to prove beyond a reasonable doubt that Donald Trump knowingly and willfully lied. And that will be the challenge. Once that's done, it'll be much easier to win the rest of the case.
Wait, did Jim say that he doubts that I kicked ass?
No, I did not say I doubted. I just said.
I was like, wait a second, what? What?
No, I didn't say that at all. So Lanny, we lawyers, we analyze, cases through the lens of presumption of innocence and the burden. But, when you get to the jury trial, I mean, it's what 12 people think it is. And
that's
so
right.
Isn't former President Trump, facing an uphill battle going to trial on this case in the District of Columbia? Isn't that a really tough hill to climb for him?
So I really, with all due respect, resent mentioning the District of Columbia because it's used as a dog whistle for Black people. And you didn't mean it that way, and nor do I think Sarah ever meant it that way. But I have fallen into that unconscious reference to the District of Columbia. I believe in the jury system and the voir dire system. Sometimes jurors will violate the law, violate the judge's instructions, and nullify what they're supposed to do as citizens, which is to only make judgments on the evidence, whether they're black, white, Jewish, or Christian, or Muslim. So that, to me, is the challenge. In the District of Columbia, the judge will instruct. You can make your decision based only on the evidence. And on the issue of lying, if I could just go on, or unless you would like to respond to that, Jim, regarding my reference to the District of Columbia, I believe in the jury system. Some juries will violate their instructions, but most juries do not.
And I agree wholeheartedly with you, Lanny. And as an example would be what I believe an example would be the Paul Manafort trial. I mean, that jury worked really hard, gave him a fair trial. He was not convicted on all counts, as I recall, and it was it was a shining example of how juries are supposed to operate, in my opinion.
Well, if I could just go on regarding the need to prove subjective intent, which is the challenge. When you say someone is lying, I always avoid that word when I'm doing any TV appearance, unless I can prove somebody had a subjective intent. I say false, and it is not a crime to say something false. If it were, there wouldn't be enough jails in the country for politicians who say things that are false. But let's just go to the heart of Sarah's very, I thought, brilliant defense, which is, how do you prove somebody's subjective intent? That's been a problem for prosecutors for a long time. Certainly in mob cases under RICO, which is a racketeering conspiracy statute, the prosecutors had to prove the Godfather's intent to be part of the conspiracy to kill people. And of course, the Godfather never said, kill that guy. He might just say, or she might say, but in this case, it's he in the 5 family trials in Brooklyn and in New York. I don't like that guy. And that's all. And the guy would be killed or whacked. Mm-hmm. So there's circumstantial evidence that a jury, to your point, Jim, has to use its common sense.
Right.
It won't be a smoking gun. I lied and I ordered a death. He did a signal, a code. Or there's an inference that's unavoidable. You go to bed at night and there's no snow on the ground. You wake up in the morning and there's snow on the ground. There's an unavoidable inference that most common sense jurors would say, yep, I am certain beyond a reasonable doubt that it snowed overnight, even though nobody saw it snow. That's the challenge of the prosecution.
Well, so my response to that was, we'll let Jim decide if it makes sense to jury using common sense, was that, and we don't know, I just read something about Trump's cell phone records being subpoenaed, or Jack Smith getting the cell phone records and whatnot. So we don't know what the government has in terms of evidence. But my argument was that typically, when somebody is lying, they are inconsistent. And that's how, as lawyers, we get people on cross-examination is that their story has changed. It's like either become more elaborated, or at least it's materially different. So my argument to this jury in the mock trial was, well, privately and publicly, Donald Trump was always consistently standing by his belief that he had won the election. This was not a big lie. It was a big truth. But, if the government comes out with some sort of a text message or something to, that confirms that he actually knew what he was believing and saying is false, then to Lanny's point, that's clearly evidence of criminal intent. But from the indictment, I don't see anything, So, anyway.
Since we've already heard the airing of our debate on NPR, and commend to your viewers to go look for it, there are 2 kinds of evidence against Trump that are now in the indictment. Mm-hmm. One is direct evidence. So it's not true, Sarah. There will be witnesses already identified that Donald Trump told me he knew he lost. Now, I
Okay.
don't.
Yeah. Well, then that's
There are a few of those, not many,
no.
but there are a few. But I, in my argument with you in the mock trial, I said I'm not relying on that. And
Yeah.
so I go back to Jim on the notion that in front of a jury, you can say, use your common sense. If somebody is looking at a black wall and he calls it a white wall and you're seeing the black wall, you do not have to have a smoking gun admission that it's actually a white wall that he's seeing and he's lying.
Right.
You can infer
that
of
course.
He's lying. And that's really what I'm resting on when I use the Supreme Court 8-1 decision that specifically said willful blindness is the functional equivalent of subjective intent. You can infer. You can infer lying by closing your eyes to what is in plain sight.
Right. So I want to ask you, Lanny, about and I know you're representing Michael Cohen. We don't, we always respect. We're both practicing attorneys. We're not podcasters, so we respect the idea that you might not be able to speak about your case in which the star witness is your client, but people that don't like Donald Trump, that definitely don't want to see him reelected, are hoping that the day will come that this man is convicted on something, anything. I mean, he's facing so many different charges for different things in different jurisdictions. And you are involved, or Michael Cohen's involved in the New York AG's case, Letitia James's case, which is going to trial. Can you tell us, in your view, what you think? Do you think the AG has a strong case? Look, your client respectfully has credibility issues. I mean, he pled, he was co-conspirator with individual number one, which is Donald Trump, in the campaign finance indictment. He did time on it. He switched a story before Congress, came clean eventually, but once a liar, always a liar kind of thing. So your client doesn't have the best track record. So taking away Michael Cohen from this equation, how does that case look? Is that a case because I ask this because presidential pardon power doesn't extend to a state conviction. So that might be the one conviction that could make a difference.
So let me do my best to keep this short because I could go on much too long. I know too much and will be much too long.
Yeah.
Two quick things about this case. I'm not relying for my first part of the answer on what I say or what Michael Cohen testifies to. Let me rely on the federal prosecutors of the most prestigious federal prosecution district in the United States. It's called the Southern District of New York. Those of us who aren't great fans of some of the prosecutors in that office would call it, they think it's the Sovereign District of New York. But let me quote them. Don't believe me. Don't believe even Mr. Bragg, who brought the indictment. It's the District of Attorney of Manhattan, by the way, not the Attorney General who brought it.
Oh, I'm sorry. Yeah, the DA Bragg, right? DA Bragg.
DA Bragg is the criminal case. Right. So let me quote the Southern District of New York prosecutors about the case against Donald Trump. It's the same case that Michael Cohen pled guilty to and went to prison. Same case, same facts, same issues. The payment of the hush money to Stormy Daniels. The Southern District of New York in a sentencing memorandum did not talk about hush money for a sex or an affair. They said, and I'm almost quoting directly, you can find the sentencing memo dated December 6, 2018, that they put into the judge to recommend a long sentence for Michael Cohen for the same crimes, essential crimes of paying the hush money and not recording it on the books. Honestly, Michael Cohen went to jail for it. And here is what the Southern District said. These crimes impair our democracy. Not about sex, about our democracy. The Southern District said, because by paying people with negative information that might influence voters before an election, those payments were made a few days before the 2016 election. excuse me, 2020
Election, yeah.
election. They said, by allowing somebody to pay off people with negative information that might change votes is an impairment of our democracy. That's what was at issue. That's why they recommended a maximum sentence. What was never in dispute is that Michael Cohen wrote a check at the direction and under the coordination of President Trump as a private citizen. Excuse me, it was before the 2016 election. So those words are what Bragg is resting on. Same facts. And therefore, this is in my opinion, the strongest case. Maybe the documents case and classified documents case is stronger.
Yeah.
But there's no need to prove intent, as Mr. Smith will have to prove.
Right.
The facts are on record, undisputed, found by the Southern District. Donald Trump directed Michael Cohen to pay the $130,000.
Yeah, I mean, look, the document case, I think Jim and I have talked about this before with another guest, I think is the strongest case. You've got footage, you've got video footage, you've got text messages, you've got lawyers who are testifying. But again, that's another federal case. And even if he's convicted, he could be the shameless president that the founders did not envision would be in power one day, and that he would pardon himself. So that's why I was curious about the DA case. But Jim, you were going to get into...
Lanny, the former president's facing a number of indictments. In Georgia, the election interference case is coming up. A lot of people have already pled guilty and agreed to cooperate. We've got the January 6th trial on the schedule to go forward in March in D.C. Then the document case in Florida seems to be behind that. I guess there's some significant discovery issues because they're classified documents. And then the New York case, as you mentioned. So how do you see this playing out, Lanny?
Well, I think that Trump will be convicted in the New York City trial. And it'll be 33 felonies because each time the books recorded the payments by Michael Cohen as a legal expense. The federal prosecutors in writing said that Donald Trump knew there was never a legal agreement with Michael Cohen when he spent that $130,000. And then as a sitting president, a lot of people forget this, he wrote checks to Michael Cohen, $35,000 a month from Donald Trump's personal bank account. The checks I put with Michael on television during his hearings, signed by Donald Trump while he was president, and recorded on the books of his company as legal expense when he knew and Michael knew, and they both knew there never was a legal retainer. And in case anyone doubts the word of Michael Cohen or Donald Trump again, don't believe me, believe the federal prosecutors. They found that both of them knew there was never a legal retainer agreement. That was a reimbursement to Michael for the $130,000 of illegal hush money with any political motivation makes it a felony. It wasn't about protecting his wife, Mrs. Trump, from the knowledge of the affair.
So when is that case scheduled? Will it go to trial before the
I am told end of March, latest, depending on what happens with Mr. Smith's earlier case that may be delayed. There will be, and I can say will be because I do talk to the prosecutor team working for Mr. Bragg. The judge has said there will be a criminal trial in March, no matter what. And no federal judge can change that. Donald Trump can't change that. The judge in New York, very strong judge, said there will be a criminal trial in March.
I mean, this guy's not going to have any time to campaign. He's going to be so busy going from court to court. It's crazy. Okay. So Lanny, one of the first things you said to me when we first spoke on the phone for that mock trial was there's innuendo in journalism and innuendo is not a fact. And you spoke about this earlier too today, is that when it comes to the presumption of innocence in the court of politics, it's more about the presumption of guilt. Jim and I call it the assumption of guilt on the courtroom side. as a crisis manager, you've worked closely with two presidents and a number of other clients who are political players. And so we really wanted to talk to you about, to take a few minutes on each story, on the cases of, or I should say the saga scenario of Governor Andrew Cuomo and then Al Franken, Senator Franken. So starting with Governor Cuomo, I've always believed he was railroaded. Just recently, Melissa DeRosa, his top senior advisor and member of his cabinet, sent me her book, which sort of gets into the truth behind all of this. And both of these cases we're talking about are based on Me Too allegations by women, obviously two men in a position of power, both Democrats, and their Democratic colleagues were not very kind to them, essentially pushed them out of office, more so than even the right. But Governor Cuomo's case was technically about 11 women who were unnamed. The laws that were broken were uncited too. And essentially, New York AG Letitia James put out this report saying, believe these women. And the women, just to recap for our listeners who may have forgotten the story, one was a non-employee at a wedding reception, where she said that the governor touched her face and put his hand on her lower back. Another non-employee in a public rope line event, similar allegations. Another one at a public event in upstate New York. Again, another photo op, a woman named Caitlin, who essentially said, I was not sexually harassed, but she was in this report. Anna Liss also said she was not sexually harassed, but was in the AG's report. A female doctor who was on national TV during the pandemic and gave the governor a COVID test. And she was dragged into this report. And apparently he had said, you make that gown look good. She also said, I didn't feel like I was sexually harassed. Alyssa McGrath was one where I guess there was some reference to being single and ready to mingle. Brittany Comiso, and then, of course, Lindsey Boylan, who had all kinds of political motivations because of things that had happened in the office when she had worked for Governor Cuomo and denied promotions and things of that sort. So, and there was a state trooper, sorry, I forgot the cop, who said that he put his hand on her waist or something like that. The Attorney General refused to rule out the fact that she was actually running for the governor's seat, and brought in a federal prosecutor who was a longtime Cuomo adversary, had animus, to do this investigation and basically run the show. And despite publicly saying that she would release all of the evidence, the notes, the transcripts, all of that backing up her investigation, to this day, she's refused to do so. And Cuomo has actually been litigating this issue for 2 years, trying to get the evidence to come out, to sort of lay out the truth. So, Jim, I think one of the things you wanted to discuss with Lanny was about the due process in all of this.
Yeah, and Lanny, is that due process, and was he entitled to due process, or was this a political issue?
Well, it's unfortunate that you're right in showing a contrast between the two, because that's today's culture, that's today's media. It's, in fact, a presumption of guilt media. It's a presumption of guilt culture, and it's contrary to due process. So I have to restrain the fury that I always experience when I read in the media innuendo and a presumption of guilt. It is definitely a fact that the media reports optics and reports, as one or more media, mainstream media, excellent reporters would say to me, I said, why did you report that story when there's no evidence to support it? Well, it's out there. So that's the smoke that you and I talked about, Sarah. And the innuendo is smoke. So right now, Andrew Cuomo has never gone to trial. His accusers have never been subject to cross-examination. And indeed, worse than an indictment, which isn't worth more than a ham sandwich, because it's a one-sided argument, It's even worse when you're accused in the media and everybody assumes you're guilty. Why? Because it's out there. You get 1 million Google hits when you see Andrew Cuomo guilt. That's so dangerous for those of us who believe in due process. And that's really what is happening with some of these instances. Having said that, I've also been a supporter of, involved with the Me Too movement. And I think it's possible to say there's a presumption of sincerity when a woman makes the accusation and often suffers a lot of attacks because of the accusation against public figures. It's worth saying, let's presume that a woman that makes the accusation is telling the truth, but it's still only a presumption. It doesn't mean she's telling the truth. She's presumed. Take her seriously, yes, but it's not the truth yet. The truth is only after due process, which is cross-examination, look at the facts, and then let a jury decide.
And don't bend the rules, because what this movement has done in the courtroom is that it has opened the floodgates to evidence that otherwise would not be admissible. Judges are, and just all unlimited number of bad act witnesses coming in to get their day in court, which is highly prejudicial. And then, bending the rules in terms of creating weird experts who could tell the jury what it's like to be this and that. And, we just saw that with the Church of Scientology. The judge literally made somebody a Scientology expert. And I'm not defending Scientology, but it's like all kinds of rules are being bent to sort of support what that believe them when they say it. And I'm like, this should not be different than any other allegation. Any allegation in court requires proof, requires corroboration. Why is it that just because by virtue of your sex you get to come in and be believed? I mean, I think that listen, Deborah Katz made a statement about this. I think with respect to Al Franken. Deborah Katz represents a lot of women with Me Too claims, and she said, the allegations leveled against Senator Franken did not warrant his forced expulsion from the Senate, particularly given the context in which most of the behavior occurred, which was in his capacity as a comedian. We'll get to that. But all offensive behavior should be addressed. Not all offensive behavior warrants the most severe sanction. So this backlashes. It's like a backlash narrative that somehow men are vulnerable to even the most frivolous allegations. And I'm just like, well, let's treat it like any other allegation. Why is this why are we wearing these, just golden gloves and doing all these weird things with this particular type of allegation? My question to you, Lanny, is the Cuomo DNA just does not give up. Okay. So I don't look at Andrew Cuomo and think, oh, he's done. I feel like he still has some sort of a future in politics. And so what do you think as a crisis manager, the best strategy would be for him to come back?
Well, I think he's failed at doing the initial best strategy. I tried actually to reach out to him, and I know Chris, his brother, very well.
Yeah, me too.
You can't wait to get your facts out. You can't be strategic and do the right timing or wait for the trial or do whatever your lawyers are telling you to do. You've got to do it immediately within the first news cycle or keep doing it over and over again. And so if I were able to get through to Andrew, I would say do exactly the opposite of what your lawyers are telling you. Do a press conference, take every question and do what Geraldine Ferrara did when she was accused of something that her husband actually did at the time. Those of you who are too young to remember, she was the vice presidential candidate in 1984, the first female almost president. And she was accused of being involved or knowledgeable about accusations made against her husband that were never taken to court, never proven. And instead of waiting for the legal advice, don't say anything, you may get your husband in trouble. You knew too much about his tax returns. It was about basically tax returns.
Right.
She held a long press conference, and it's used as a proper noun nowadays. Do a Geraldine Ferrara is what I wanted Andrew to do. And I've known the governor, so I can call him Andrew.
Yeah.
She said at the beginning of her press conference, all my lawyers have advised me, or something like this, not to do this. I am not leaving this room until I answer every question you have about my husband and my conduct. And she stayed and stayed and stayed. And once she did it, it was basically over.
But so that ship has sailed. But now that he is fighting to get the evidence and to,
Not too late. Not too late. You should do it tomorrow morning.
Really? Okay.
Really? Because
not show up with the goods once he has the goods?
Well, he can do it. It's a process, but he hasn't done it yet.
No.
And
No. He is litigating to get the material.
But we got to wait for the trial, for the litigation and the judgment.
Yeah.
I think that Andrew has facts on his side. He also has a mea culpa that he could do.
Right.
Whatever I was doing in my mind, I can understand that the woman took it the wrong way, or I shouldn't have done it to begin with. There is no crime in admitting to responsibility. That happens to be the truth. Some of the women were offended, and he should respect that, even if he said, I didn't mean it to be.
Well, but see, that's what every guy says in this context. Every guy comes out and issues a statement and says, I'm sorry, I didn't intend to do it. I'm Italian. I'm touchy-feely. I'm sorry I offended you. That was not my intention. But the culture doesn't take that as genuine, and they can't.
I have a long-standing response. You can imagine that when I do my trade of crisis management, I'm always asked that question, and I have a standard answer. I don't really care. I just want you to tell the truth, and if it's not believed, just keep doing it. And I don't really care if people don't believe you, because that's a guy's excuse, even if you're a sexual harasser. You tell the truth, and you own what you do acknowledge you shouldn't have done.
Right.
And if a woman is offended and you don't know her by touching her back, her shoulder, or saying something intimate, then own it and apologize for it. Oh, well, people won't believe him. I don't care how people react. Just do the right thing. Just tell the truth and keep doing it over and over again. Can't do it once. Have to keep doing it. That's my crisis management philosophy.
So, Jim, should we move on to Al Franken?
Sure.
Around time. Al Franken, it's a long story, but I'm going to shorten this. He was a comedian. He was on SNL. He then had the Al Franken radio show, and then he went to the U.S. Senate. During the time that he had that Al Franken show, he did I think it was a 2006 USO tour with the troops and all. And Leanne Tweeden, who is a conservative radio host, who I also know very well from a panel that I did for Dr. Drew, her and I were regulars on that panel, came out, this was around the 2017, Weinstein allegations and all that, and said that Franken had assaulted her by forcing a kiss on her, sticking his tongue in her mouth, and that later when she was asleep, he touched her breasts and then for a photo op. Except all of this was part of a skit that Al Franken had written, and then she later made a statement that he purposely wrote the skit to do this with me. And then there were women who were coming forward and saying, no, Al Franken is a goofball. He's a nerd. That's his character. That's how he makes people laugh. And you rehearsed this, right? And so Al Franken was gone in no time. And he has very unequivocally talked about how he regrets resigning from the Senate, and how Senator Gillibrand and Chuck Schumer basically gave him the ultimatum. And Chuck Schumer was like, you need to be out by 5 p.m. or else. And so where's the due process, right? Like you were just talking to Jim about it. So Sean Hannity was involved. He wanted the tape. He wanted to be the first one to show it, or the photo with the breasts and whatever. And so, what about Franken? What are your thoughts on him?
Well, I'm sympathetic, even though I was the victim of his talk show nastiness towards my friend and Senator Joe Lieberman, and he and I exchanged some harsh words about his treatment of me on his radio show. He actually hung up on me when I was defending Joe Lieberman. So I don't speak with any friendship or kindness towards Al Franken, given before he was a senator, the way he had treated me on his talk show. But I am still very sympathetic because he was run out of town without a trial. I think he did apologize for what he did do in whatever way that he apologized. I accepted his apology, but he was not, it wasn't right that he was given an ultimatum by his colleagues. He deserved a hearing. He deserved a chance to defend himself. He deserved a chance to apologize, but it wasn't an offense given the circumstances that should have driven him out of the U.S. Senate. So he didn't get due process, and I'm very sympathetic towards him. I'm glad I finally got my chance to say how really rude he was to me, but he just it's a long time in my being able to say that, but that maybe increases my credibility by I'm very sympathetic. He should not have been run out of the Senate.
You're not going on his podcast anytime soon, are you?
No, well, I still really love the guy as a U.S. Senator. His views on issues were the same as mine, quite liberal, and he was a great comedian. He just could be, as people will tell you about him, very, very rude when he wants to tell you he doesn't like you or your friend.
Turning over to Jim.
Yeah, on these issues, particularly these sexual harassment claims, I mean, it really does depend, in my view, is whether the accused, when you're in the political arena, is the accused a Democrat or the accused a Republican? Because the Republicans will stand by, the accused, whether and won't throw him out with the bathwater the way the Democrats will with Al Franken and Andrew Cuomo and I know the Supreme Court is a whole different a different venue and has such long lasting consequences. But you just look at Brett Kavanaugh, for example. I mean, the Republicans stood by him in the face of withering accusation from his college days, and I just don't think a Democrat could have survived that. I'd like to hear your assessment. I mean, you got friends on both sides of the aisle, but it does seem to be a political equation when it comes to treatment of the accused in that arena.
So look, let's go back to the very, very important name of your podcast, and the importance of your podcast is your name. And that is the absence of the presumption of innocence. And there's more hypocrisy on the side that I live on, which is on the left. I'm a card-carrying member of the liberal wing of the Democratic Party on every issue I can think of. Maybe fiscal conservatism appeals to me sometimes. But the fact is, we liberals are more hypocritical and the Republicans less by giving the presumption of innocence. When it was Joe McCarthy, as I was raised before you two maybe were born, when Senator Joseph McCarthy used pure innuendo, no facts and no evidence, to ruin people's lives. He actually led people to commit suicide when they were accused of being a communist, and they had no evidence, and they were blackballed, and some of them took their own lives. We liberals would say, wait a minute, it's just innuendo. It's just, and now when it comes to Donald Trump, or when it comes to anything that involves an accusation by a woman, we go to the presumption of guilt rather than staying with the consistency of what we said in the McCarthy era, is there's a presumption of innocence when you're accused of being a communist. So this is the lesson of our times. And I know my fellow liberals get upset with me when I point out the hypocrisies of having one standard if it's McCarthy, another standard when it's Trump. And I think we need to be intellectually consistent as believing in due process.
Couldn't agree with you more. Just back to Al Franken. Obviously, you would not have been advising him, considering your past. But had you been advising him,
I would have actually.
Like a good lawyer.
Yeah. What would your advice have been? Get out in front.
I would have said, "Hang in there, Al.
I'm a comedian."
I would have said, "Hang in there. Don't let anybody bully you, whether it's a colleague from New York, a senator, or anyone. Demand a hearing and get your due process." And then I'd say, "P.S. Al, you owe me an apology."
I have a question in closing before we leave. What politician client in your career would you? Well, wait. Actually, let me back up. Were you advising President Clinton when that Monica Lewinsky thing was going on, or is it a different time?
No, I was out of the White House.
Oh, okay.
My wife was about to deliver our now 25-year-old son.
Okay.
But I remained a private citizen. I did a lot of television to defend him on the impeachment because there was really nobody else available.
Mm-hmm.
And he was an old friend. But I did find my own way as a private citizen to talk to him and to try to give him advice.
So what client then, what politician client of yours was, you think, the biggest success story you've had in terms of being able to do damage control, get in front of it, manage the crisis?
Well, I could plug a book that I wrote called Crisis Tales, 5 Rules for Coping with Crises in Business, Politics, and Life. And I give a lot of case studies of my favorite stories. But Martha Stewart was one of my favorite, unfortunately not a success story in the outcome of her criminal case because her criminal lawyer forced me to be terminated after I placed and worked with Jeffrey Toobin and published a story in the New Yorker entitled Lunching with Martha, where I invited Toobin to sit down with Martha Stewart and hear her story, which was never a crime of insider trading. Someone named James Comey, the U.S. attorney at the time, the same Comey that delivered the election to Trump by writing an illegal letter to Congress 11 days from the election in 2016. Don't get me started. In any case, Martha Stewart's story is a great story where I defied the legal advice. We went to the New Yorker. The story that Toobin independently researched found, no, it couldn't be insider trading because she got a tip from a broker, not from an inside official from the company. And ultimately, Mr. Comey, who I think acknowledged that Jeff Toobin's New Yorker story influenced him, did not charge her with insider trading, even though the media had convicted her in headlines of insider trading. That's one of my favorite success stories.
Did you end up helping Toobin also?
No, well, I certainly didn't get called on to help him, but I was very sympathetic to what happened with him to this day. I'm a great fan of Jeff as a journalist, as a lawyer, and in all other ways. And I think what happened to him was very unfair.
Lanny, that just points out the difference between, I guess, a crisis manager and a defense lawyer. And we talked at the beginning of the show about how difficult it is to prove intent. And what we see in most of these white collar cases is the charge ultimately that sticks is making a false statement. But you have to make it to a federal investigator. You can't make it to the media. But that's why defense lawyers tell their clients, don't talk. And that's not the best strategy for someone in the public eye, obviously, trying to get ahead of a story. But
there's no question I respect my fellow lawyers. The reason I stayed as a lawyer, as a practicing lawyer, by the way, I am now on my own with the name Lanny J. Davis and Associates, so the prior identification in your wonderful introduction of me has been updated, Sarah. But my decision to do this work and always do it as a lawyer is because I needed to be in the room with my fellow lawyers under attorney-client privilege so they could tell me the risks of going public in the media. And I always cleared my messages with fellow lawyers that they were facts that wouldn't prejudice the client. So whatever my rules of being out in front, my expression in the White House that was a subtitle to a book I wrote about my White House experience, tell it early, tell it all, tell it yourself, has some exceptions. And that is the criminal defense lawyer. I do not want to say anything to the media that would prejudice the case because it's not important enough to save a reputation if the person's going to jail. So there's got to be a balance between the legal risk and the reputational strategies. And it's not an easy balance to strike, but I need to be a lawyer trusted by fellow lawyers to at least share facts with me under attorney-client privilege.
You know who did that, Lanny and Jim, in the recent past was Alec Baldwin. Alec Baldwin did not care what his lawyers were telling him about the Rust shooting. He was on with George Stephanopoulos giving an interview, very detailed. He was on all these different, and he was on social media talking about the incident while criminal charges were pending against him. But I mean, ultimately it worked out. But the statements he made were not, they were hurtful to him. There is that sort of,
well, but they dropped charges. I'm not sure how hurtful they were.
No, they dropped. Yeah, that's what I'm saying. They dropped the charges, but for evidentiary reasons. Had they brought the charges, his statements were not good. I mean, and they're still not good on the civil side. I think he ended up settling. But my point is that is always a concern. But I also think that, lawyers are good crisis managers because we deal with that all the time. Although you do it on a whole other level. So I'm not at all comparing.
No,
you do.
Both of you get the idea that if we're going to get due process, we have to get our facts out into the media because media is poisoning public opinion, which can infiltrate. Notwithstanding what I said earlier about the voir dire and the jury system, it can certainly infiltrate into the mindset of a jury if there's prejudicial publicity. But I know one thing, you only get one chance to keep your reputation intact. And in the age of Google, if you don't immediately get into the news cycle to contradict a false statement, the one thing I always say to lawyers, and I am unyielding on this, I'm always willing to listen to the legal risks of going public. Mm-hmm. If I've got a positive fact, don't tell me that it's going to hurt the client for me to get a positive fact into the media. Maybe it's not the client speaking. Maybe it's me speaking as his lawyer. But the positive fact, if I'm sure it's a fact, cannot be harmful. And I have to win that argument with my fellow lawyers. Now, sometimes I lose the argument and I then go along with what the lawyers want. But I always make the argument.
Lanny, as lawyers, we have, once there's a pending case, there's an ethical rule that kind of limits us as to what we can actually say in public.
May I interrupt you and say that's not true and we have a respectful disagreement?
All right.
I know that's always said.
Yeah.
I can quote you the ethical rule, chapter and verse. It's got to be prejudicial. Don't forget the word prejudicial. And I always say to my fellow lawyers, and not one single judge, I've been challenged on that ethical rule. You're not allowed to use the media you can't litigate in the media. Excuse me, Your Honor. Read what the rule says. I can't say anything prejudicial to the media. I have an obligation to my client to correct the record with facts. So I turn to my lawyer, the other lawyer who's challenging my going to the media. Can you tell me whether what I said is factually accurate? Because if it is, there's no violation. And I never get challenged beyond that challenge because, of course, I don't say anything to the media that I don't have backup on, documentary evidence, that I know what I'm saying is true. Sorry to interrupt.
I appreciate that. What we're seeing is a trend where judges are imposing gag orders on the lawyers in some of the high-profile criminal cases. And then, President Trump, I mean, he's subject to some restrictions on what he can say. And so that's...
So again, it's a very difficult balance. In the case of a judge who's trying to keep a jury from being unbiased, it's very difficult to criticize a judge when it comes to somebody who's constantly using social media and constantly making statements that are opinion statements and not fact statements. So judges have a tough job, and sometimes erring on the side of a gag order is necessary. But in my case, I'm very careful with what I say to the media in litigation, as well as even not litigation. I better be right. I have made mistakes in comments I made to the media, and I learned a lot of lessons from those states. So at least we can all agree that if a client is being harmed in a reputation, as certainly Al Franken was, as Andy Cuomo has been, as other people have been, the truth is the only defense. And if a lawyer has the facts and can document them, I think it's the lawyer's obligation to get out in front and worry about reputation as well as the case.
Mm-hmm. Well, I mean, look, when we represent clients, it's holistic. Of course, the number one focus is, their defense and against the criminal charges, but we also have to consider collateral consequences. Is the guy going to get deported? Is the guy going to, lose his professional license? I mean, there's all these, there's a whole spectrum of things that, literally I say, I do this work because it has to do with life and liberty. I'm not fighting over money. And it is life and liberty.
Yes. And let me, again, we're almost ending our time, to compliment you on your choice of words in what you're doing on your podcast. The word presumption is in our Constitution, at least it's an inference from the Due Process Clause. The presumption of innocence actually doesn't appear in the Constitution, but it's been inferred over the years by courts because that's what due process means. When we see an indictment announced by a prosecutor at a press conference, no one's requiring that prosecutor to hold the press conference. Why does the Justice Department allow a federal prosecutor to hold a press conference, to put out a press release? What's going on there? Is it okay for prosecutors to try to influence juries by holding press conferences? And then when defense lawyers try to answer the press conference, it's too late. Yeah. The headlines have already been dominated by the prosecution. I'd love to see Merrick Garland, of course it will never happen, say no more press conferences. Yeah. We'll let you all read the indictment, and the indictment speaks for itself. And you may remember Mr. Fitzgerald at one point, who was a special counsel who indicted, I think, in the Bush years. And he said at the beginning of his press conference, let me remind everyone, the presumption of innocence is the person we indicted is innocent until proven guilty. At the very least, I'd like to require that to be the rule for every prosecutor who holds a press conference, but it's never going to happen.
Brilliant idea.
That's a great ending. Thank you so much, Lanny, for coming on. This has been very, very informative.
Thank you for your podcast. And do me a favor, I don't want to be up against Sara, at least in the near future.
And if you want to check out that debate, you should go to opentodebate.org. They have a podcast channel there. You can see Sara and Lanny throwing it down, or you can also check it out on YouTube. And while you're on YouTube, you should visit our page, youtube.com/@thepresumption. That's our social media handle. We're on all the podcast platforms, so please subscribe. And just to echo what everybody said, hope everyone had a great holiday season. Happy New Year. We're so excited to keep releasing shows for you guys. And until then, Sara and Jim.
Until next week, we
rest.